It is roughly 10:01 on Wednesday, November 1st, and would like to call to order the Property Tax Consultants Advisory Council meeting here at TDLR, and I'd like to remind everyone that this is being televised and recorded on YouTube. So in the event that you do speak, either publicly or whatever, please state your name first and last. And with that, that is item A. I'll go to item B and do the roll call. And we definitely have a quorum. Glad to see that. I want to thank TDLR staff for putting this together for us. It's been a long time since we've all gotten together. And secondly, I'd like to welcome Deborah Balcom to the advisory board council, and welcome, and glad you're here. Appreciate your service, and also say thanks to Judy Cullors, who has since retired, and thank you for her service. So with that, I'll take the roll. Steve Mills, I am present. Stephen Dunstan,
here.
Mr. Bill Green,
Present.
Mitchell Katin,
Here.
Deborah Balcom.
Here.
I am saying that correct.
Balcom.
Balcom, yep. Mr. Ken Parsons.
Here.
Mr. Paul Pennington.
Here.
And with that, we do have a quorum and all present. And I think item C is the next, going to training of board members.
Good morning. For the record, my name is Mark Gladney with the Office of General Counsel. I'm here today to give you a brief training session on the Texas Open Meetings Act, the Administrative Procedures Act, and the Public Information Act. Now, due to time constraints, if you have any questions or suggestions, please contact me after the meeting, and the office will be happy to assist you. We're certainly here to support you, and you'll find additional information on the legislation in your briefing material. So this is not going to be an exhaustive analysis of the laws, but provide you with some helpful information and some best practice points intended to assist you in the performance of duties. Okay, as I said, we're talking about these three pieces of legislation: Open Meetings Act, Administrative Procedures Act, and the Public Information Act, which is also known as the Open Records Act. Okay, we'll start with open meetings. Okay, the primary purpose of the Open Meetings Act is to ensure open and transparent government. And you're going to hear those two words quite a bit through this presentation, open and transparent, because it applies to all three pieces of legislation. There's the overriding legislative intent of these three pieces of legislation that government be open and transparent. You've heard the term sunshine, putting sunshine on what happens with deliberative bodies. A meeting under the Act must meet the following requirements. Okay, TDLR, this applies to TDLR and an advisory board or committee. They must give written notice of the date, hour, place, and subject of each meeting held. And the notice has to be posted at least 7 days prior to each meeting, and TDLR will provide a notice of meeting to the Secretary of State for posting on the internet, and then also TDLR will provide notice of the public meeting on its websites. And certainly when we talk about subject matter, the description on the agenda has to be reasonably sufficient to inform a member of the public as to what it is you're going to be talking about, regarding that agenda item. Now, a quorum of governmental body, including this board, must be present in order to make it an official action. Now, there's 7 of you on the board, so we do have a quorum, as you've stated previously. So a quorum, a minimum quorum for this council is 4 members. Okay. Now, if a quorum wasn't present, so if 3 of you were here or less, you could certainly meet and you could discuss items on the agenda, but you couldn't take any official action or make a decision. Okay. Now, a governmental body such as this board may only meet to discuss public business or public policy under its supervision or control, and may only make take formal action on matters of same. So You know, you're here to talk about property tax consultants, not laser hair removal folks or podiatrists, that kind of thing. You're really ranging out the reservation if you do that kind of stuff. Okay. Now, are social functions considered meetings? If a quorum of the governmental body is present at a social function, so you're out at, party or conference or whatever the case may be, that is unrelated to public business that you all oversee, the gathering is only subject to the Open Meetings Act if the members engage in discussions about official business over which you have supervision or control. Okay? Now, are social functions considered meetings? A board or committee is also not engaging in formal meetings if there's a conversation amongst y'all that is only incidental to the social gathering. Now, if you're at conventions or workshops or conferences, board members that attend these things and a quorum of you are present, so minimum 4, you're not engaging in a meeting as long as the conversation is about public business or public policy and it's incidental to the actual event that you're attending, and no formal action is taken amongst you at the conference, convention, or workshop. So here's a few things you need to remember. Always be aware of your surroundings. Always be aware of where you're at outside of a noticed board meeting, especially when there's 4 of you or more present. Don't engage in any substantive conversations. Remember, we talked about substantive versus incidental discussion. But don't engage in any substantive specific conversations related to board, business, or policy when there's a quorum present and you're outside of a noticed meeting. That's a big no-no. Don't do that. And beware of the walking quorum. All right. Which is kind of apropos since we just came out of Halloween, because this is important. Okay, walking, or they're also called traveling quorums. These things occur when less of a quorum of board members discuss official business through any means and communicate those discussions to other board members. So while less than a quorum participates in the initial conversation, subsequent discussion will result in a quorum discussing official business outside of a public meeting. So, let me explain this. Let's say board member A and B are out to lunch. And there's an important rulemaking going on, and it's pretty controversial, and lots of moving parts going on, and A and B are sitting around having lunch. And A's done some research on a particular issue related to the rulemaking, and has come up with some great ideas. So board member A starts talking to B about it, and board member B is like, man, that's some great ideas, I really like that stuff, So after the lunch, board member B comes across board member C, at a basketball game. And they start talking about what board member A said. And board member C is like, oh yeah, I didn't think about that. I'm going to have to consider that, when the next time we meet. Board member C talks to D, and so on, and so on, and so on. So the conversation, the original conversation between board member A and B, eventually gets communicated to all the members. That's known as a walking or traveling quorum, and that is a huge no-no. So the best thing to do is not to engage in this, and if you have any discussions, that any ideas about things that are pending before this board that are within your supervision or control, the best thing to do is to have the conversations in an open forum. Once again, when we talk about open and transparent government, this is key. This is why you don't do this kind of stuff. Okay?
Mark, one question. That includes email exchanges as well, does it?
Yeah, any communication. It says through any means. Okay? So that could be emails, it could be letters, carrier pigeon, Facebook, Twitter, that kind of stuff. Got to be extremely careful about this. Okay, that's an example I didn't use. Okay, and this goes to your question. They can occur in, walking quorums can occur during conference calls, video conferences, hallway discussions, emails, text messages, and then, of course, Facebook and, all the other social media means of communication, So if you come up with an idea, and it's only human nature where you might want to talk with, other board members about things. I've been on boards, I've been in elective office, and it's human nature to want to maybe chat, or maybe bypass what the rules are related to quorums and open meetings. So it's not that unusual, but you got to fight that urge, okay? And if you really have a great idea, that's what we're here for. That's what staff's here for. Come and talk to us. We're more than happy to hear from you. I'm brand new, so nobody calls me right now. So if you want to call me, fine. I'd be happy to talk to you. Okay? Okay. So again, best practices to avoid the walking quorum. Board members should not meet in small groups, discuss board business, and then communicate those discussions to other members. Send emails or text messages to a quorum board members or committee members regarding official business, even if each email is addressed separately, to y'all, because the walking quorum can still occur, okay? So you can't get around it that way. Ask a quorum, don't ask a quorum, even on an individual basis, for feedback or comments on board business outside of the meeting. This is called polling. So it's like, well, hey, what do you think about this issue that we're contemplating, that kind of thing, to another board member. Don't do that. Okay, so the board is limited to discussing the specific items on the agenda. So I don't have my copy of the agenda, but the agenda, think of it as a roadmap. That's what it is. You stay within the four corners of the agenda. That's what you discuss when you have a properly noticed meeting. Just those things and things that are related to the issues that are on that agenda item. Not straying off into some other issue. If you do find yourself in a situation where an ancillary issue pops up on the agenda item that you're discussing, you can always suggest to have it placed on a future meeting. So that's the best way to get around that. Okay. During the public comment period, members of the public are given an opportunity to speak to the board, and of course the board can set reasonable limits, time limits for that. So it's kind of up to you, but I think 3 minutes is what I've commonly experienced in the past. A member of the public or a member of this board may raise a subject that has not been included in the notice, but any discussion of it is limited to a proposal to place it on the agenda for a future meeting, just like we just talked about a few seconds ago. Okay. To avoid violating the act on the basis of insufficient notice, the board members should specifically identify items for agendas and communicate those items to staff. Limit the discussions to the specific agenda items contained in the posting filed with the Secretary of State. Avoid letting discussions regarding specific agendas wander off into new issues that haven't been noticed, so staying on the reservation. Not respond to or discuss issues that are raised during public comment, but which are not on the agenda. So you get a member of the public comes up here and raises an issue, and y'all may think, hey, man, that's a great idea, But it's not related to any item that's on the agenda, your little roadmap. You can't respond to those things, and you can't discuss those because they're not properly noticed on the agenda. But you can always make a suggestion. Hey, this person from the public had a great idea. Let's put that item on the agenda for a future meeting. And then you can discuss it as much as you want. Okay. As I said before, it wouldn't be much of a law unless it didn't have some penalties attached to it. There are civil remedies that people can take for actions that the board takes in violation of the Open Meetings Act. It says any interested person, including the media, may petition the courts to stop actions that are taken in violation of the Open Meetings Act. Yeah. So any official decision or official action that's taken by the board that's in violation of the act, it's a voidable act. It's not void from the point at which you make it, but if someone decides to go to district court and ask for injunctive relief, stop the board from going forward with an official action or a decision, and they produce sufficient evidence to a judge to say so, then the court can issue an injunction and it can stop whatever official decision or action that this board or any other governmental body decided they wanted to do. So that's one part of a situation that can occur when a violation of the Open Meetings Act occurs. The biggie is that there's also criminal penalties attached to this. Any board member who knowingly conspires to circumvent the open meetings law by meeting the numbers less than the quorum to secretly deliberate is subject to misdemeanor criminal penalties. The penalties can be anywhere from a fine of $100 to $500 or confinement in jail for up to 6 months or both. Okay? So that doesn't necessarily mean that Texas Rangers are going to come and swoop in through these doors and provide you all with matching cufflinks. But it's just you don't necessarily want to be the first test case for something like this. So the best thing to do, the best practice is whatever business you want to do, you should do it right here when the meeting is properly noticed. Okay? Okay, so again, avoid communications that involve a quorum of board members about official business outside of a properly noticed meeting. And during the meeting, confine your discussion to the roadmap, which is the agenda. Okay. All right, that takes care of the Open Meetings Act. Now we're going to move to the Administrative Procedures Act as it relates to rulemaking. So, here's the purpose of the Administrative Procedures Act, to establish minimum standards of uniform practice and procedure for state agencies, and to provide for public participation and transparency during the rulemaking process. Once again, open and transparent government, sunshine. That's what this act is talking about as well. And a rule is just simply a statement by a state agency that implements, interprets, or prescribes law or policy, or describes the procedure or practice requirements of a state agency. So a rule just basically interprets a statute. The legislature passes a statute, and then the agency interprets what the statute actually means, or implements how the intent of that statute is going to be carried out. Okay, a rule must always include amendments or repeal of prior rules, if any, and a rule does not solely relate to internal management or organization of a state agency. Okay, so anybody can petition for a rulemaking, and anybody, Texas resident, a business, an advisory board, or any private organization that's not a state agency. Okay, so here's the basic rulemaking process. Somebody comes up with an idea for a rule, and the draft rules are sent to this board, and then proposed rules are filed with the Texas Register, so that people out in the public are aware of, hey, this is going on. The public has 30 days to comment on that proposed rule, and they'll do it in writing. And then the General Counsel's Office will review the comments and recommend rule changes, if any. And then the advisory board, reviews the comments that are made, and you make a recommendation to the commission. And the commission reviews the rule following comments, and if everything goes right, they'll adopt the rule. Then once the rule is adopted, it's published in the Texas Register, once again, so that the public knows what decisions were made by the commission pursuant to the recommendations that this board is given. And once it's filed with the Texas Register, 20 days later, boom, the rule goes into effect. Okay? Now, the legislature also requires agencies to review administrative rules every 4 years. All right, so the agency files a notice of intent to review, and the public, once again, has 30 days to comment on the rules that are being reviewed, whether or not they should be repealed or amended, modified in some way, The General Counsel, once again, takes a look at those comments, makes a recommendation to the Commission. Commission will review the rule filing and comments, and they may decide to re-adopt the rule. They could also make some other decisions. They say, well, maybe it might be time to amend it, change it, repeal it. The advisory board will be presented with any comments and may recommend changes. Okay? And that's pretty much it for the APA. Now we're moving to the Open Records Act. And this is basically, taken straight from the statute, Government Code Section 552.001. Not going to read the whole thing, but the bolded parts are what's important. Once again, we're talking about open and transparent government. Government is a servant. Policy of the state that each person is entitled at all times to complete information about the affairs of government and the official acts of public officials and employees. You are public officials. Okay? The people insist on remaining informed. Okay, so the Open Records Act makes all documents, records, and other information relating to official business open to the public. Of course, there are some exceptions with, to just about every rule or law. Public information includes any electronic communication created, transmitted, received, maintained on any device if it is connected with official business. Now you notice we underline the word any. Okay? That means any device that you use, whether it's personal or it's issued by the agency. Okay, so you should take great care to not necessarily conduct public business on your own personal devices. So iPhones, Androids, tablets of any kind. Because if we do get an open records request, that could also include the information off of your personal devices. So it would behoove you, if you want to maintain privacy, to not do any work related to official business on your own personal devices. Now, if you receive a public information request, or something that looks like it, you need to forward that request to the Office of General Counsel as soon as possible, because there's time limits associated with how long we have to respond to one. Approximately, we have 10 days to respond to an open records request. We don't have the right to ask anybody why they want the records. If they make a generalized request, we can certainly ask for them to clarify and distill it down to what they actually want, but we don't have the right to ask them why they want it. They can ask for it. If it's a proper request and it's information that is not accepted by the Open Records Act, then we will have to give it to them. Now, I talked about exceptions. There's exceptions to things that we have to provide. There's a number of them, but there's information that will be redacted off of documents when we get an open records request, such as a person's date of birth, email address, certain educational documents, and medical records. Those things will be protected under the state law. Okay. Well, and that pretty much concludes my presentation. If you all have any questions or suggestions, my number at the General Counsel's office is 512-475-2108. Yes?
My name is Mitchell Katine, and I think what you said is that the rules of an agency are supposed to be reviewed every 4 years? Is that right?
Yes.
Okay. Are there rules promulgated for property tax consultants?
Yes, there are.
Okay. So we haven't met since 2009, and I was just wondering, that's more than 4 years. Is there some process by which this advisory council gets the rules, looks at the rules, has an opportunity to make changes to those rules?
I would assume, Della, we've looked at those every 4 years, correct?
As far as I know, I can check with our rules coordinator. That's a time before I was involved in this, 2009. But normally what we do, the process would be, this is Della Lindquist, sorry, Deputy General Counsel, and what we would do is bring them back before you if there was any changes. So what we may have done is brought them to the commission to just re-adopt, but we would still have to publish them for comment. That, because we do our rulemaking in the 4-year rule review in 2 phases. We basically, number one, just make sure that they're still necessary and the statute is still requiring us to regulate this program, and then we publish for notice and comment round 1. And then if comments come in from that initial readoption proposal, we do a more deep dive into the rules. So that's an excellent question, and I will see what the process has been since the last time these were reviewed.
Okay. I'm just curious because
Right.
if we don't know that this is going on or have an opportunity, I don't think we've, said here, check out the rules. Do you have
Right.
any changes or suggestions? Because if we're not asked that, then we really don't know that if we have a rule that we want to suggest be changed, didn't really have that opportunity to do it.
Right,
So-
and I will, as soon as we adjourn here today, I will get with our rules coordinator and find out what the process was for this particular section in the administrative code and get back with you.
Okay, thank you.
Steve Mills here. Most of our rules, if I'm not mistaken, are actually changed by legislation and change in the statute as it regulates property tax consultants and licensing.
This is Della Lindquist again. We would implement what the statute asks us to
Right.
do and set fees, because there wouldn't be fees and things like
Right.
that in the statute itself. Normally, what it would say is that the commission shall adopt rules to regulate this program. A lot of times, it's pretty broad.
Yep.
And then that allows us to set fees, that allows us to set licensing procedures and processes and things like that. When the legislature meets, and if they were to change this
Right.
law, that would drive us to a rulemaking. That's another type of rulemaking activity. But you're correct that legislative mandates drive the rules, but we don't always change the rules based on the statute.
Great question, Mitchell. Great question.
Because it's been my experience that if it's a specific rule, if it's a rule that does not necessarily require interpretation, then there's really not a reason to make a rule. You're just basically repeating the statute. And that's-
Which is usually the case for us.
Ken Parsons. I can't recall an instance, but I believe I have seen through email in the past rule changes or suggested things that change within the TDLR that affects our group. And I'd have to go back. Maybe you guys could go back and find some of those, but I believe they circulate those out as a for public information. And I believe I've seen a couple of those over the years, although it's been a while since our group met. I do believe that's going on, just because I recall seeing some things along the way, so we can
Yes,
find
and
out
you
what
may
those were.
have Della Lindquist again. We do have an email notification system that maybe most of you hopefully are on or can get on, but then you would be apprised of any rulemaking or any activity that this program had, which may not necessitate a meeting. But if there were to be any changes in the rules or propose anything like that, it would go out that way and notify you that we're going to be publishing these rules for comment.
Mark, one last thing. If there's any council members that would like a copy of his PowerPoint, could you provide that?
Absolutely.
This is very, very important information. It certainly protects the public. It's transparency and accountability, which is what we're all about, certainly in our profession. And it's the kind of stuff that's kind of like raising your first kid. You don't know what you don't know. So it's just very, very helpful for us to have this information. We appreciate you putting it together in your efforts there.
Thank you. And just remember, as part of the agency's core values, it's customer service, and that doesn't just mean external customers, it means internal customers. You're an internal customer.
Thank you, Mark.
Thank you.
And with that, we'll move on to item D, which is approval of the minutes from our last meeting, December 10th of 2009. A lot of water has gone under the bridge since then, hasn't it? So if... Literally. Yeah, no kidding. So if everyone's had a chance to peruse that, and if we have a motion to approve it.
So move.
And a second?
Second.
Motion made by Ken Parsons and seconded by Paul Pennington. Approval of the minutes from the meeting of December 10th, 2009. And that opens us up to item E, which is the public comment section of the meeting. And any...
Mr. Mills?
Yes.
Mary Winston, TDLR. You have to request a vote for the minutes to be approved.
Okay.
And then we'll move on. Yeah.
I digress.
It's been a long time. I
Yes,
know.
it has. And do I have a approval of the minutes, and is there a vote on approval of the minutes?
A motion.
A motion? And we have a motion from Ken Parsons. We had a second from Paul Pennington.
And the vote?
And the vote is? All in favor? Aye. And the minutes are approved. Thank you. This is very uncommon for me, to say the least. So now, we will go to public comment section, item E. And any persons that wishing to address the advisory board should complete a public comment form and submit it to the program specialist. And we see none, so there is no public comment at this time. And so that moves us to item F, which is staff reports and a briefing from the staff and discussion. And first off with the executive office.
Thank you. Mr. Chairman, board members, I'm Nick Foenis of TDLR, and here to bring you our executive staff office report. It's a summary of what's been happening around the agency here. But first, wanted to thank you for being here and thank you for your service to Texas. Since state lawmakers have gone home, so to speak, after a very busy 85th legislative session and a special summer session earlier this year, our staff's been busy preparing to implement legislation and new programs that were passed during that time. It's a total team effort, as all of our divisions are involved in this process, and it includes developing rules, communicating to stakeholders, appointing and prepping advisory boards like yourselves, hiring additional staff, dealing with education, exams, IT programs, and more. And speaking of new programs, on September 1, we picked up the state's podiatrists, and today we add 6 more health-related programs from the Department of State Health Services. This is phase 2 of the 13 total programs we were granted 2 years ago. So beginning today, we add code enforcement officers, laser hair removal, massage therapy, mold assessors, remediators, offender education programs, and sanitarians. Next September, we'll pick up the state's behavior analysts. But I want to mention that as we add programs granted to us by the legislature, lawmakers also have deregulated 5 of our programs since 2003, and will deregulate 4 others in the next 2 years. We recommended that action after our strategic planning process, which included public and industry feedback, and the legislature agreed that the licensing requirement for these programs were unnecessary and burdensome, and doing without them posed little or no risk to customer or consumer protection. Also, over the last 2 months, our staff has been working hard to help our licensees and small businesses in the Gulf Coast area. recover from the devastation of Hurricane Harvey. Everyone at TDLR deserves mention here. It's been a total agency effort. And we've been working in coordination with the governor's office and the governor's Rebuild Texas efforts, and have been implementing procedures for all of our eligible licensees in the affected areas to help them recover and return to work as quickly as possible. We started several days before Harvey hit the coast, and our staff has extended license expiration dates. They've waived late fees and license replacement fees, waived CE requirements, and extended grace periods for expired licenses in those affected areas. In summary, we've tried really hard to remove the burden of red tape to help Texans rebuild as quickly as possible. You can find information on all this on our website, tdlr.texas.gov, and also at the Governor's Rebuild Texas site. Also like to take this time to promote our social media avenues, accounts. We are on Facebook and Twitter. So if you're into that and would like to keep up with our events and news, that would help you there as well. But back to the website for a minute, I wanted to share some recent web traffic with you. Numbers associated with this program. Over the last 6 months, the Property Tax Consultants website had 12,260 page views, and it's an average of 67 a day. And also 67% of those visitors accessed your site from a desktop computer, while 30% did so from a smartphone and 3% from a tablet. The top reasons for visiting the site, the top reason is pre-license education list, and followed by FAQs, continuing education providers, applications and forms, and laws and rules. And if you have any questions, I'll be glad to answer them for you. Otherwise, thank you very much. Yes, sir.
Mitchell Katine, I'm just curious, the 9 programs that became deregulated, not requiring licenses anymore, what kind of programs were those?
Can I piggyback? And Mary Winston, TDLR, and I'm going to take us way back to 2009. I'm not going to quite go back that far because I didn't work here in 2009. So I can research, but I wasn't here, and that was the last time that we saw some of you, and this is the first time we've seen others. Since 2009, we have quite a few different faces here. I believe a couple years ago, I arrived at TDLR in 2012. I did speak at the TAP conference with Roger Thormalin a couple of years ago. Roger's since retired, so that's one change. But since we all met, we had Bill Kuntz, who was our executive director, and Brian Francis, who was our deputy at the time. Bill has retired, and upon his retirement, Brian was selected to be the executive director. Well, since Brian took over, and we've been calling it TDLR 2.0, Brian saw fit that instead of a single deputy, how about a deputy? Because we've grown so much. We have incorporated 7 new programs from the last session, Senate Bill 202, and we onboarded the last 6. And today is Go Live, and if you all don't have this wonderful document that I'm looking at, we'll make sure that you get it, because today is Go Live for massage therapists, mold assessors, laser hair removal, offender educators, code enforcement officers. And now we even regulate transportation network companies, otherwise known as Uber, Lyft, etc. So we have quite a lot going on. But what we say what we always say during the session, and what I know I said during the last session was, they said, why is TDLR taking all this? We are taking nothing. But when the legislature just gives it to us, we say thank you, and we do the best that we can with what we have. So our new deputy is Carla James. She is downtown today because our new director, Brian Francis, is actually speaking at the Business and Commerce Committee at the Capitol this morning. So Carla, we have her downtown. And Nick, who just gave us our great report, is our new chief of staff. I'm not aware that TDLR previously had a chief of staff, but I don't know because I'm only 5 years in. They haven't had one since I've been here, but we've grown just almost exponentially. So Nick Bowen is chief of staff, Carla James deputy, Brian Francis is executive director. Also, to get back to your question, those programs that were deregulated, career counselors, that was before I was here. Talent agents, also, don't remember that one. PEOs, personnel employment services, loss damage waivers, temporary common worker employers, these were most recent. Vehicle protection, product warranters, vehicle booting, and for-profit legal service contract companies. Those were deregulated, basically because, for instance, in the vehicle booting, it's handled at a local level. We didn't want double regulation. We were an impediment to getting that job done. The legislature saw fit to deregulate that. For-profit legal service contract companies, it's a contract. So the remedies are found within that contract, and that again would be double regulation. They saw fit to take that away. And so for the things that were deregulated, it was things like that. Now, the new programs that we are regulating are not new, except for one of them. We inherited some programs during the sunset process from the Department of State Health Services. Also, we now regulate driver education and safety. That was pulled over from, it was split between, was it DMV and TEA? So just by the way that it was regulated before, they saw fit to pull it in and to, thank you, Lee, to let us handle that regulation of driver education safety. And that's been onboarded very successfully, and we've inherited and hired a lot of staff to handle these things, and the onboarding has gone well. The programs that are coming on now are overall DSHS programs. TNCs, Uber, Lyft, etc. That's a new regulation. That's a legislative move, and they saw fit to bring it to TDLR. We will be moving forward with behavior analysts. That will become effective in 2018. That's a whole new license. And those individuals are counselors for autistic services. So I hope I've answered your questions. I don't know if I've left anything out, but it's a lot to cover. Yes, sir.
Mary, this is Bill Green. You said tow truck operators are no longer?
Oh, no, we no, sir. Vehicle booting.
Vehicle booting?
Yes,
Okay.
we still
Well,
regulate tow
if I
trucks.
remember, didn't we have a mid-forum meeting that you spoke at up at Alliance Airport
Yes.
last year? I think me and Mr. Dunson attended that,
Yes, I thought I recognized you,
Yeah.
Mr. Dunson.
and there was a lot of those folks there.
Yes, and we still welcome them to the TDLR family. I was just speaking to our prosecutor. We switch things up a little bit to keep it fresh and to make sure we do a lot of cross-training, and she'll get up when it's her turn to speak for enforcement. That was her program. So we've changed a little bit. Just the booting. It was handled locally and differently in different cities and counties, and so legislature saw fit, well, why are we doing it when it's locally controlled, and they remove that from us, and we're not mad about it. It's okay.
I can't tell you, we're not as rowdy as the tow truck.
There was quite a show up.
Appreciate it.
They showed up for that meeting.
At least
They
yet.
show up. They show up, and they have a wonderful conference as well. And you guys have a wonderful conference, but you just don't have a lot of problems. So, which is a good thing, very good thing. With the rule review, we do want to get you in here more often, because Kim and I were talking. I got here in 2012, and she got here in 2013, and Nick is new. We just had a lot of change and a lot of growth, which has been necessary because we've just been blessed with a lot of different and varied programs. But we don't want to neglect our older members or our more seasoned members. So we do want to get you in here. We do have a standard way of rule review. But if your program, if your profession was a problem profession, or if the regulations were changing substantially because statutorily they were changing, you would hear from us more often. But I will tell you, you will hear from us more often than you have in the past, because as we've grown and changed, we've gotten new members, and we were identified, advisory boards in particular, as a core competency that had to be addressed. We have so many. I think it's 32 now, I'm not sure. We counted up 216 or 17 advisory board members, and that's before we bring on the new programs. So it's nothing we want to ignore. It's something we want to make sure we do well. So you will be called in, and hopefully you won't be like maybe a program or two that shall remain nameless. Why are we meeting again? Because we need to. So thank you.
And I'm sorry to interrupt. This is Della Lindquist again. I'd like to piggyback off Mary to assure you that indeed we are compliant with the law. I've communicated with our rules coordinator to find out how the 4-year rule review was handled since you've met. The last one was in 2015. In March of 2015, the rules were readopted by the commission. I understand that unless there's something pressing to hold a meeting, that first phase of the 4-year rule review is really independent of having a meeting. It's just simply to publish, get comments, and readopt to comply with the law. Then if a meeting is needed after that to go into phase 2, to go over comments that came through, we would do that. For some reason, that hasn't happened, but the 4-year rule review was accomplished in March of 2015, so 2019 would be the next time. However, 4 comments did come in, she sent me during that rule review. So it might behoove us if at the next meeting, when we set that agenda, if you wanted to appoint a work group, if you feel like looking through the rules and dealing with the comments that came in at that time, it would be, we can't appoint it today because it's not on the agenda, but the next time we meet, it would probably be a good thing to appoint a work group, and then we can do a little deeper dive into the rules if you feel like that's something you'd like to do, and see if any rulemaking is necessary based on your review of it, which is the phase 2, which is when we usually go in there, and then take into consideration those comments.
Thanks for drilling deep down into that, and Mitchell, thanks for the question. I think it's probably be important for us to get that over.
Thank you. I'm relieved as well.
Hey, Ken Parsons, can I ask one quick thing? Are you still having your annual, I'm thinking annual meeting where you solicit feedback from different council members on better ways to do this? What do you do well? What do you need improvement on? Are you still doing that?
You're doing that so well, Mr. Parsons. That's our strategic planning. And thank you. Brian Francis, he will love this. This is his script. This is something that he and Bill came up with, and these are the questions that we ask. It's biannually, and it's coming up. We have a legislative session, strategic planning, legislative session, strategic planning, legislative session. We just finished a session, so we will be heading right back into strategic planning. How are we doing? What are we doing well? How can we improve? If you were king or queen for a day, what's the one thing that you could change? And I'm probably forgetting one question, but we'll ask them again. So that will be coming up. We will put that out in the email blast, and if everyone is has signed up to our email listserv, you'll receive several notices of where we'll be to have an opportunity. We try to come to several major cities, as many as we can in Texas. We try to spread it out, so we will have that availability coming up in a few months.
Ken Parsons, I think that's an excellent place. I have attended a couple of those meetings in the past. It's been a number of years, but I do think that's a good point, a good time to, if you have a question about how often a council meets or if there are issues that we feel like we need to handle, that's a good time to say, you're doing this well, but we probably need to improve over here by having more sessions or more meetings. If the rules and the agenda, calls for it, I think that's a good time to bring those types of things up rather than wait till we get to another meeting after this many years and then say, where have we all been? So I think that's a good forum.
Thank you. That will be coming up pretty soon, so we will definitely have that opportunity.
This is Paul Pennington. I want to follow up on the review of the rules that you were addressing just then. So to put that on an agenda for the next meeting, what process or what would we need to do?
I think toward the end of this meeting,
definitely.
there's a place to discuss what's going to be on the Della Lindquist, Deputy General Counsel, there's a place to discuss what would be, what you'd like to see when
Okay.
and what we'd like to do at the next meeting.
Yeah, okay.
So what I might recommend is that agenda item for the next meeting would include something like appoint a work group to look at, to review rules, and then you would appoint some members of you, less than a quorum, to work with us in looking at the rules, dealing with the comments. Then at a future meeting, bringing the result of that work effort to the board again to see if any rulemaking you'd like to actually implement or make some rule changes. So it's a few meetings down the road, but probably start the process at the next meeting by appointing a work group to look into the rules and deal with the comments that came in.
Okay, thank you.
Is that all the items for the executive
Yes, sir.
portion?
Thank you.
So the next item is item F2, which is the Compliance Division, personnel changes and public outreach. Thank you, Nick.
Good morning, board members. My name is Russell Tolley. I'm the program specialist for this program in our compliance division. I have two general items for you. One is personnel changes. Prior to this year, Roger Thormalin was the program specialist for this program. So if you called in and asked questions or asked for research, you probably spoke to Roger. He's a great guy, and I hope he's enjoying a happy retirement now. So congratulations to him. Lisa McDonald was another PTC program specialist. She's been reassigned to another division within the agency. I am now the sole PTC program specialist. So if you have any questions, comments, or anything you'd like me to do regarding research for the program, please let me know. My email address is probably the best way to get a hold of me, and it's in my report. The second item on my report is public outreach. I want to let you know that I am available to attend any industry meetings or gatherings you might be aware of. Please send me an email. I'll be happy to talk to anyone, do a question and answer program. If you want to refer someone to the agency and they're looking to have some questions answered, please feel free to pass on my email. I'm happy to work with the general public, customers also. If there are no questions, that concludes my report.
Anyone? Thank you, Russell.
Thank you.
Next item is item F3, Education and Examination Division, which will cover current projects and updates, education, examination, and school services, personnel updates, division chart, and statistics and trends. You have quite a list there.
I do. My name is Lorraine Schroff, and I'm with the Education and Examination Division. Good morning, Chairman and board members. I am not going to read that entire report since there are several items in there. You do have all of the information, and as you review that, we'll be happy to answer any questions that you may have. I would like to highlight just a couple of items for you. If you will notice, there is an exam review committee meeting scheduled for later this month. It will be on November 30th, and that will be here in Austin. And that meeting will review and add any additional items that need to be augmented in the item bank for the examinations. Also, as Nick has already shared with you, our main focus has recently been helping the schools in the Harvey area that was affected, and then, of course, implementing those new programs, getting those exams ready, and the continuing education ready. You have the statistics in your report of the exams and for the continuing education. As you review that, if you have any questions, I'll be happy to answer that. Otherwise, that concludes my report.
I have a question.
Sure.
Mitchell Katine. I'm just curious, and it's been a long time since I've been at a meeting, so please
Sure.
excuse me if it's not appropriate. I'm just curious why you're reporting on these other professions here today. Why is that in your report to us?
As far as the Phase 1 and Phase 2?
Yeah.
That is just for information purposes. just to let you know that new programs have been added.
So as the Education and Examination Division, it covers all of the agencies
That is
and
correct.
professions that Texas Department of Licensing regulates.
That is correct.
Okay,
We
so-
have a part in every program.
Okay, so property tax consultants, but when we get down to the exam, like the exam review committee, that's only the property tax exam, consultants.
That is
exam.
correct.
Okay,
We do different reviews at different points through the year for every program.
okay. And so for the examination statistics, that again is only on the property tax consultants.
That is
exam.
correct.
Okay.
That is specific just to your industry.
Okay. And I'm a public member, so
Okay.
I'm learning
Sure.
a lot. So for example, my question would be, to get a property tax consultant license, you have to pass an exam,
Correct.
and you just pass it once, you don't have to take it ever again, is that correct?
That is correct.
Okay, but there's, I presume there's continuing education requirements.
Yes, there's 12 hours of continuing education that's required. When the property tax consultants renew their license, within that year period of time, they have to do 12 hours of continuing education.
Okay. And that's under your department?
That is correct.
And each one of these, is it fair to say that most of these professions, from massage therapy to laser hair removal, have that same arrangement? They pass a test and then they do continuing education?
For the most part, yes.
Okay.
It's either an exam through our agency, or it could even be an exam through a national exam, depending on the program. And almost all of those have continuing education requirements as well.
And you regulate the providers of that as well?
Some of the providers we do regulate. Most of the health professions, we do not regulate the providers because those courses are provided through colleges, universities. Some of them are medical fields, so they get those through those type of associations. We actually do mainly an audit basis of those programs, and in fact, moving forward here, we're getting ready to post a position, and we're going to hire an auditor for our division as well to start auditing some of the CE providers that we do regulate. So we're moving more towards an audit-type system.
Thank you.
You are welcome.
Bill Green. So did you personally kind of take over the umbrella of what Don Dudley used to do?
I did not. Our director is Ray Pizarro, and I'm one of the program specialists.
He is retired.
He did retire, another personnel change.
Steve Mills here. How often is the questions and the exams updated? We get new legislation through every session as it relates to our industry.
True.
And taxpayers' legislation. So how often are they updated, the exams? And do you have any feel as to, do you think there's a need for an update to the questions?
The exam review meeting that I mentioned that's coming up later this month, that is the purpose of that
Okay,
meeting.
okay.
The subject matter experts come in with our exam program specialist, and they review the items of the questions. They see if they're relevant, if they need any changes, if they need to add new questions. So that's the whole purpose of that committee. And I do not have the date of when the last meeting was, but this is the whole purpose of that committee.
And who are the individuals that are on that for our particular?
The subject matter experts. I don't have that list with me. I'd be happy to get that for you. And
Steve, this is Paul Pennington. In the past, it's been Judy Cullors,
Yep.
Ken Parson, Shane's
Daughtry. Yeah.
He represents the appraisal districts and myself,
correct.
and we meet every 2 years. But it's this is Paul Pennington again, it's my understanding that there's some new
I believe they have added some new
experts
members.
that have been added
Yes,
for this upcoming meeting.
Yes,
correct.
this is Deborah Bacco. I know Carl Van Hook's been chosen, and I think Jeff Berger is now going to be on that committee as well, who are property tax consultants in our industry.
Okay. Thank you.
And so there will only be two people as considered experts?
This is Deborah again. I
No.
think they've been added, I don't know.
Oh, added.
Yes, they are
Paul, you're
added to
still-
the,
This is Paul Pennington again. I think this year, Ken, you're still on it?
Yes.
So I think there might be 5 or 6 this year.
Awesome.
yeah, there's several.
Ken Parsons, I know that the correspondence I've received regarding the meeting, I haven't seen the addition of
The new
anyone else.
members?
I know I've seen Paul's name on there, and Shane Daughtry's name's on there, but I don't recall anyone else. Now, you say Carl Van Hook and
Jeff Berger.
Jeff Berger have been added. Okay. I haven't seen those on the correspondence, but I assume that they'll be.
And
in our
PSI,
meeting.
our third-party vendor, is actually the one that sends out those notifications. So, but if you want that information, I'll be sure that they get it to
It
you.
was more for the benefit of the public than for my
Okay.
own knowledge.
Okay.
I have another question, that's Deborah
Sure.
Malcolm. So if we are reviewing, if there's a committee being assembled to review the exam for November 30th, when would those new questions, or, I mean, because there have been some significant changes in the law that our
Sure.
education providers need to be aware of to help instruct new consultants. And so when would those questions be implemented into the exam?
Exam, all of that process would be handled at that committee time.
Okay.
They would explain to you the procedures, they would explain to you what you can do and what you cannot do, and then at that time, a determination would be made as to when an exam question would be added, because we, of course, have to update the candidate information bulletin, which gives that information to those individuals taking the exam. So that would all be determined at that meeting.
This is Paul Pennington. Deborah, it's going to be like, if we have the meeting in November, the test questions might see the light of day in February or so of 2018.
Yeah, that's a good
And legislation is
timeframe.
one that will be updated. Yeah.
Yeah, it just takes time for them to, update that material, get their systems updated with those questions and that kind of task.
Yeah, this is Ken Parsons once more. Just one more comment about that is, they ask for additional questions every time we meet. So they give us an assignment that we individually write questions to bring to the meeting.
Right.
And then I believe, as Paul said, that it takes them 3 or 4 months to get to incorporate those into the exam,
Right.
which I'm assuming they would not give an exam without the new questions or without at
That is
least
correct.
anything pertaining to the change in the law. They would probably either omit that question if there is an exam given, or they will wait until the spring or February maybe.
Yeah, there
to-
would be a specific time and date as to when that would go into effect, because we do
Obviously-
let the public know as well.
Obviously, the exam would have to be updated with the changes in the law.
Correct.
You can't give them the old exam anymore, so
Correct.
I'm sure we'll discuss that at the meeting.
Yes, you'll be discussing quite a few things.
Steve Mills here. Paul, Ken, and Deborah, we appreciate y'all doing that. It's a thankless job. It's mind-numbing and not overly exciting, but we appreciate the efforts and all the work in the past and currently and here to come up pretty shortly in that effort. And it's vitally important that we have qualified people representing
Yes, it
taxpayers.
is. We rely on you heavily.
Yeah, so we really appreciate that and all the efforts in that regard. And Carl and Jeff also as new members there. So, Raina, I don't think there's anything else, but thank you
Okay.
very much.
Thank you.
Next item is Enforcement Division. Cover highlights of the selected cases and enforcement statistics, which is item F4. Moving right along.
Good morning, Chairman Mills and other advisory board members. My name's Kim Davenport, and I'm a prosecutor with the Enforcement Division, here to give the staff report. And since it's been a while since you've met, there were 7 orders that were entered. I actually just combined them because 2 of them were against the same individual. Actually, 2 of the agreed and 2 of the defaults. So I just put them all on here so that you had all the information, basically, of what's happened since your last meeting. The majority of these were agreed orders, which means that the department came to some sort of agreement with the respondents in these matters. There was one that was simply based on a record-keeping violation, relatively small fine. The others on the agreed orders were mostly based on some sort of misrepresentation that was given between the respondent licensee and his client. Some sort of either misleading information in the contract or misrepresentations that were made. And I'm happy to give more details regarding that. I know some of that is already in your case highlights, but I'm happy to give any more details. There are also 2 default orders that were entered since the last time you met. Both of them were actually against the same individual for unlicensed activity. I want you to know all of the penalties that have assessed in all of these cases have been paid. All of these people have licenses in good standing currently, which is good information and not the norm for most of my reports. So I'm happy to address that. If you have any questions about the case highlights, I'm happy to answer those now, or I can move on to the next portion.
Got one question for you. Steve Mills here. If you have a habitual repeat offender, is there any type of 3 strikes and you're out and you get launched and you're no longer have that ability to operate in this state?
I
'Cause
don't.
that seems like that's always the case.
I don't specifically handle these type of cases, but I do know with TDLR and all of our programs, we kind of have a system to where if you have had a prior violation within 3 years, the next violation, as long as it falls within a time frame, is a second violation and usually enhanced penalties. And it depends on the level of the violation. If they're all record-keeping violations, probably not going to result in a revocation or a suspension of your license. If you have pretty serious violations, some of them that are classified may be classified higher to where they can look at either a revocation or a suspension of your license. When those matters happen, of course, a lot of times those are going to be contested matters, of course, because no one wants their livelihood taken away. And we also have to have the commission to approve any revocation or suspension if it's not agreed upon or defaulted on, which at times people just don't respond. And it gets defaulted and their license is suspended or revoked in our system. But if they're serious enough offenses, I don't believe, though, that the revocations are lifetime. I think for the most part, they're usually a year.
I can speak to that.
Thank
This
you,
is
Della.
Della Lindquist, Deputy General Counsel. In addition to, well, there's no such really three strikes and you're out, are the basis upon which to revoke a license, there's many factors we look at, and then we have also the penalty matrix, which classifies each violation in each set of rules from less serious to more serious. And so some you could possibly be revoked for the first time doing it, and some maybe not. It just depends. And then if you have 2 or 3, the penalties would increase. We also have, and we are utilizing more frequently, injunctive relief. We work in conjunction with the Office of the Attorney General, and because we can't go to civil court on some of these, but if there are recidivists or someone who's like unlicensed and repeatedly does this kind of thing, we work with the Enforcement Division and refer those over to the the Attorney General's office, who can then go into court and pursue an injunctive relief, which would theoretically could stop someone from doing the unlicensed activity, though.
Steve Mills here again. Is it something that you think would be a good agenda item for discussion amongst the advisory board, or you think it's?
You mean to study how a person can get revoked?
Yeah, I mean, like if you have a repeat offender that just he's just a bad actor, and he does the risk assessment, he knows what's going to cost him dollar-wise, and he does it anyway. And so at some point in time, you got to say, okay, we're all out of fun. You're done. And because it seems like that's always the case. It's usually somebody that just repeatedly, not just, makes a mistake and doesn't do something administratively.
You could take a look at the penalty matrix and see if there's something in there that you might believe, because normally that's brought before the board when we establish the matrix, and if there's no changes. We haven't made any changes to it, I believe, since it was established. But you could always take a look at the penalty matrix on the website for this program and see what kind of violations are assessed as A, B, C, D, or more, and if you see something there that you think should be elevated or something like that, you're certainly welcome to weigh in on that. Normally, the Enforcement Division takes care of all that, so if you have a concern, you could contact Kimberly.
And Mary Winston, again, actually, we have several new people. Jessica's sitting here, Ms. Hurtado, and she's going to be the attorney for this program. The penalty matrix, we have a penalty matrix for every program here at TDLR. The Enforcement Division develops it, but we do run it past, review it with the advisory board. It's been a minute. It hasn't been updated, so that possibly is a good thing for us to look at. It's a snapshot of the violations, and we change them. I call it a living document. Some things may have been perceived as a problem violation at some point, and I repeat, you guys have a great program. You're not a problem program with repeat offenders, some, but not like others that we may have. But if there's something that several years ago was seen as an issue and carried with it a certain level of a fine or penalty or what have you, and if that's changed, that's something that we bring in front of the advisory board members we typically have a work group to take a deep dive in and look at those and see, do we need changes, and then to come back to the full board to then suggest changes and have the full board accept them. That then goes up to the commission to accept your recommendation. So there hasn't been a dive into that, and I think we could possibly add that for our next advisory board meeting.
So Mayor Steve Mills here again. So you would advise we do it as a work group prior to an agenda item?
Prior to an agenda item. The
Yeah.
agenda item would be the work group.
Okay.
And then
Okay.
you have the authority to create that work group. Our work groups don't meet in person unless you just love to drive in. We phone calls, Skype, whatever we need to do to get you together. That would be the enforcement attorney typically handling that, kind of coordinating it. Chris Russi is the analytics specialist in that division. Haven't met him either because he hasn't been here since 2009. But he would help coordinate this, and it would be an agenda item because we have to notice it, that we're going to appoint a work group. You would do that in front of the world and YouTube, and at that point, excuse me, the work groups would meet when they were available, and another agenda item in the future would be discussion of the work group meeting findings or something like that.
Ken Parsons, do you have any licensees that y'all regulate that you do have a clause or you call it 3 strikes and you're out? I mean, is there an actual where you can actually revoke someone's license for some long period of time, or maybe?
There are, Mary Winston again, there are reasons that a licensee may be revoked. And they vary from program to program. What may be for a tow truck driver or combative sports fist boxer or whatever, that would be different. And that is a real license. That would be different than for you guys. That's something I don't want to hold up the meeting, but we can look into the matrix. It is on our website, and not sure what it is for this program. But there are reasons in different programs. I know typically if there's a felony or state jail time, that's an automatic revocation. But there are other methods where we would seek revocation. But that's something that I don't think that any of you all have looked into. So I think we need to take a look.
This is Paul
If it's up to you.
Pennington, and I don't think I'm talking to anybody on the staff who is here who knows this, but the repeat offender that you're talking about, issues came up in the past, and the TDLR consolidated like 15 or 20 complaints against him, which resulted in a six-figure penalty. So we know that that penalty, whenever it occurred, but we know it's been at least 8 years. And since that penalty occurred on that group, I'm looking at this, and that group's only, done something bad apparently twice that's resulted in a penalty. So I guess from my perspective, the penalty that was assessed by the TDLR, and this character had a Attorney General penalty that was huge. And it just seems to me that I think since those two things happened, and we're looking 8 years down the road, and we only have two fines on that particular group since then, it appears to me that what the Attorney General did and TDLR did had an effect on the way that particular group is running their business. That's just food for thought.
Duly noted, and that's two that there was complaints filed that was acted upon, not including the other things that they may have done, that there was no complaints filed. It may just be me. It may just be a big deal for me. It may not get any support even making it a work group, but I thought I'd throw it out there and see. But that's a great point, Paul.
Well, I think that's very helpful for you to look at the enforcement plan because you work in this field. The attorneys, this isn't our wheelhouse, so it's very helpful for people who actually work in that area every day. You may see something as a lot more serious than we do, but we try to take all the information that you have given us and that we can through the statutes, of course, and the rules, and employ that in our penalty matrix and our enforcement plan so that we are, treating the more serious ones to try to deter future actions.
And Mary Winston, one more time, I had a chance, since you all were chatting, to pull up the penalty matrix for property tax consultants. And currently, they're classed A, B, C, how we typically class them on up to whatever the greatest classification is, a violation. In the penalty matrix class B for property tax consultants, a first violation comes with a monetary fine of $1,000 to $5,000 and/or 1 year probated suspension up to revocation. So basically, revocation is on the table in your profession pretty early on. In other, before moving to this position, this actually was my program, and I was a prosecutor in enforcement. Other programs, revocation may be a level D, E, F, and you guys is a level B. So we don't have a great amount of complaints in your area, which is great. We all know who we're talking about, but that's been several years ago. Class C simply goes to revocation, first violation, second violation, third violation. If this is something, Mr. Mills and everyone, if you want to just take a look at it, it is available, our enforcement plan on our website. You don't have to make it an item. You can make it. It's up to you, definitely, as the chairperson. And if someone else would like to have that on the agenda for the future. But it's just, I think it's been a while since we met, and so we just are getting more familiar. We'll be seeing each other more often. So if we need to do that's fine. But in the meantime, you can definitely take a look online and see what that matrix is.
Thank you both for indulging me, and we'll throw it out there later and see if there's any interest.
Hey, Ken Parsons, I suggest we put that on the agenda. Maybe just to at least look at, review, to see if we all feel, because I think we all know exactly where you're coming from.
Yep.
And I do think that's something probably needs to at least be reviewed and talked about, discussed a little bit to make sure that if we do have, the whole idea, I guess, is to protect the public, right?
Yes.
And if we're going to protect the public and we do have a bad apple somewhere, we probably need to find out if we have enough teeth in our governing docs that would take care of an issue like that.
And Mary Winston, one more time, and if you just would like a review next go-round for next meeting, it would be Jessica more than likely, and she's new, so it would be another exercise. She hasn't gotten up yet, but Mark has already volunteered and put his phone number out on YouTube, so everybody can give him a call. But if it's something you just want to just put on the agenda for review, that would be great. You guys have not met, some of you ever, some of you in quite a while, so we will definitely do that, Mr. Parsons.
This is Deborah Balkum. Just clarification, so there's 7 violations in our entire industry since 2009 or since 2013?
I can't say 7 violations, 7 orders that were
Orders.
reached. So we felt there was enough evidence to proceed with a violation, but there were 7 orders, 5 agreed and 2 were defaults.
Since,
Since
the
the
last
last
one's
time you met.
13 on here, but is that since '09?
That is my understanding from the report that I received.
We can get clarification on that.
curious.
Yeah.
I mean-
Not sure. We're just not sure. Because I thank Kim, Mary Winston again, I have to keep saying that. I thank Kim for making this presentation because we do have so many new staff members. She doesn't work this program, but we can get clarification on that for next time. We can. Because I'm not sure, and I know you're not sure either.
I believe, they generally pull all the cases. However, also our legal file system only goes back so far.
Yeah.
And there could be some that were very early on that maybe weren't in our actual computer system because everything is
We have
Okay, well
on a
then at the
special
very least
system,
since
too.
13.
Yeah. I can tell you right now, we currently have 8 cases that are open. And so it is a very small amount compared to other programs, although, like Ms. Winston said, that just speaks to there's less bad apples, definitely in your area.
Bill Green, I think this data is all available on the website. You can go in and look at the actions that are taking place. You just have to go under property tax consultants, and pull it, and I looked at it the other day, and it goes back further than 13.
Yeah, I can venture to say with certainty, there's a lot more than that. There's probably that many per year,
Okay.
for sure. I mean, you just
We'll
at
look
the-
into that and see what else is out there and look into our system too to see what other actions that we have taken prior to that date and have that information for you.
I guess then the only other item that you had left was the enforcement statistics.
And just, I believe you have the report in front of you, but just to point out, just like we've said, there's relatively few complaints in this program as well as in terms of other programs. However, if you look at the collection of penalties, it's a much higher percentage than in most. 65% last year of the penalties were collected. I know I generally do tow and VSF, and we're very happy to get a quarter of our penalties paid. Of course, very, very large program there. So, like I said, the statistics are there for you, but a relatively small amount of complaints or cases opened regarding this particular program, but luckily, we've been successful in collecting those penalties that have been assessed in these cases. Do you have any further questions you would like to ask? Thank you so much.
Thank you very much, Kim. Now we move on to our last, the staff reports, which is item F5, licensing division, licensing statistics, and recent developments.
Good morning, I'm Tarsha Red, the licensing manager for Property Tax Consultants, and I too am new to the program. I've been with TDLR for 8 years, but managing this program since September 1. As you can see from the report in front of you, there's not a whole lot of movement, but there has been some growth since 2009. We've had an additional 169 licensees added to the program overall, 84 senior property tax consultants and 89 regular property tax consultants, and then a slight decrease in the real estate property tax consultants. So not a whole lot in compared to other programs, but still a good bit of movement in the past 8 years. Any questions?
Question, Bill Green, so does this make you part of the Blazers team?
Yes.
Okay. So you also are part of the team that regulates property tax professionals?
Yes.
Do you know right offhand what the number of regulated property tax professionals is?
I do not, but I can get it for you.
What's the difference between a property tax consultant and a property tax professional?
A property tax consultant actually consults with an individual or for a business. They work for that person, whereas a property tax professional works for a taxing agency.
And those are, is there a property tax professionals advisory council?
Yes.
I know, but that's just, that just seems a little strange that it's not all one brought together.
Well, actually, Mary Winston again, it's two not
Very
opposing
different.
sides, but
They're very different.
the property tax consultants represent individuals, entities, what have you.
Right.
You know what they do. You're on this board. Property tax professionals would be those people, those individuals who you're presenting this information to.
Right.
So
They work for the appraisal district.
they work for the appraisal
I
district.
understand. I still don't know why
It's separate.
there wouldn't be, is there a liaison? I mean, is there something where you all get together with them and work things out?
Other than tax season, y'all?
Well,
It's a very different,
Steve Mills here.
different professional
For
license.
clarification, their rules and their legislation is totally different than ours.
Okay.
Yeah, they're issuing the bill, and on the other side, you're trying to help minimize what's paid.
Well, I understand that. I just, as a consumer, I just think that there's some overlap here for the whole industry as a whole. But maybe it's, I mean, I understand, well, you know, because when there's a dispute, as far as going forward, both sides are involved in the dispute, and whether it goes forward on an appeal or litigation or whatever, I just, okay, thank you for the information.
This is Ken Parsons again. Just
Yes.
one quick comment about that is we do have a member of the property tax professionals on our exam committee. Called a minute ago, Shane Daughtry. He is part of the professional property tax professional group. And so we do overlap some because we do go by the same code and all that sort of thing. But they are two completely different groups, and that, like I think Steve said, you know, their legislative agenda may be different than ours. Frankly, I'm quite sure some of them have filed grievances against property tax consultants and perhaps
Vice versa.
yeah, vice versa also. So, yeah, they are different enough, but we do overlap enough to say that we do abide by the same rules and laws, and so consequently, that's why we have a representative on their exam committee, and then they have one on ours as well, so.
And Mary Winston, statutorily, the requirements for each board is very specific, based on the law. And y'all are letting me exercise my fingers today. So I've gone over to the PTP board, Property Tax Professional Advisory Committee, sorry. And Shane Daugherty represents professional appraiser. We have public members. We have to have a certified registered professional appraiser, certified registered tax collector, or registered appraiser. So very specific member requirements for that board. Just as with this board, it's a specific requirement. So it's just different, and it's just based on the laws.
Three comments, Steve Mills here. We, actually, Shane and I had a discussion, I think it was one of the strategic planning a few years back. Judy wasn't able to make it, so I came in her absence, and Shane was there, and we sat by each other, and we actually talked about having a joint session, or just a kind of a conference, for lack of a better term, kind of a roundtable workshop to kind of air things out and things like that. It never came to fruition because of our schedules and just the tax calendar as it came out. That one comment, so I would certainly be open to that if there's any support for that. The second comment is, no one at this table refers to them as the dark side, but there are taxpayers that refer to them as the dark side, so that's fine.
Well, I would support that proposal of at least some activity together for the good of the industry and the public. So.
Well, there's great mutual respect for the assessment community. I hope there's great respect for our industry as well from them, but we can't speak for them. But we would certainly be open to that, and I'll maybe make that as a motion.
And I would also, I'd add, Bill Green, I would add that 4 of us up here used to be on that side.
Yep.
So we certainly
Yep.
understand it.
Yep, absolutely.
Interesting.
Well, I'm getting to know both sides, so it'll be a fun ride either way.
Well, there's some great people within their industry, for sure.
All right, anything else? Thank you.
And with that, thank you very much, Tasha. With that, item G is recommendations for agenda items for the next council meeting.
This is Paul Pennington. I would like to recommend a review of the rules that pertain to property tax consultants be placed on the agenda for the next meeting.
Do I have a second to that?
Second.
This is Della Linquist. Do you want to appoint a work group at the next meeting to deep dive, or do you want to do some actual review of the rules next time? All of you?
I think I think we should, would it be, you cannot appoint the committee until you have the meeting the next time.
Because it's not on the agenda this time.
And so there's nothing we can do between now and then except everybody think about the rules.
Mm-hmm.
So what would be the most functional way of doing this?
The agenda item, Mary Winston, would be something like review of current rules or penalty matrix and possible appointment of work group. So we can put it like that,
That would be perfect.
and so you can choose, okay, we'll
Sure.
do that.
So it's actually going to be coined as review of the property tax consulting rules, current property tax consulting rules.
Do we want all the rules, or do we just want our enforcement plan penalty matrix?
The rules I'm interested in are requirement rules.
Okay, so review of the rules. Okay, and possible appointment of work group.
So that would be all the rules? Is that what you
If
said?
that's what you're saying.
Why don't we leave it
that's what I'm
open-ended
saying.
at this point, just, and
Yeah.
then we can pick and choose what we want to.
That's right.
at that point.
Deborah Baucom, can we also include the comments that we received in 2015
Yes.
to make sure that we are looking at those as well?
And with that would be the penalty matrix as well, because it's part of the rules. So it wouldn't be a separate item.
I think it should be a separate item. It's
Okay.
actually an enforcement.
Okay.
And we
function.
can, that's shorter than the rules, so we can actually do that as well. We typically, when we do a review of, or when enforcement does a review of penalty matrix, they put it up on the smart board, and you can kind of, so everyone can see it, people out in the public can see it, and just do a run-through.
What would be the most efficient?
Separate
Separate?
item,
Okay.
yes.
So do I have a motion to add the?
I make so move.
Okay. Do I have seconds?
Second.
So we want to add the penalty
Review,
matrix
yes.
review as well.
Can I just, this is Paul Pennington, can I ask a question? If it's placed on the agenda for the next meeting, does that mean that there can be a general discussion during that meeting? Or is it just, you're going to appoint a
We will
group?
place it as review and discussion.
Okay.
As long as we notice it clearly enough, then we can do that.
And there can be public comments at that point as well?
There cannot be.
Does it have to be on the next meeting, public comments?
Public comments would
As
have to
part
be-
of the agenda?
Yes.
Gotcha.
In that regard, could you send us a link or a copy of the rules?
We can definitely, it's available on the website, but we will gladly send you a link, a direct link to that.
Okay, thank you.
Delia.
I'd like to ask for an agenda item for consideration of a joint event with the Property Tax Professional Advisory Council, and just leave it open like that, and we can discuss what's the most appropriate thing to consider.
I will second that as well, I guess it's appropriate.
We typically term a summit when we get people together and we notice at a
A
different.
summit?
A summit, yeah.
That's fine,
So,
okay.
well, we get you together and we have, TDLR has a certain way that we kind of get these things going and have comments and so forth. But next meeting, we'll be able to flesh out exactly what, or more towards what you're looking for. And we can talk with Shane and other PTPs and kind of get it going.
So make sure you charge all the expenses to their division. They get the Chick-fil-A bill.
Was there a second to that motion?
Yes, it was for me.
Okay.
Anyone else? You want to vote on the agenda items that we've added? Can I hear a aye?
Aye.
All in favor? Aye as well.
Okay, I wanted to say also, I had Delia hand you guys a copy of TDLR at a glance. This is a rundown of where we are today. It's a snapshot, just for your review. Some of the questions, some of the items that we discussed, and I sort of ran over this in my explanation, but you can see how many programs we've added. We have color-coded per legislative session, the questions about the deregulated programs, and when those were deregulated, and so forth and so on, and numbers for our licensee body, so forth and so on. So just for your review.
Thank you, Ms. Winston. Thank you. Item H is the discussion of the next date, time, and location of the next council meeting.
Mr. Chairman, Nick Valens, we've got 3 possible dates for you in February. We've got Wednesday, February 14th, Valentine's Day, if you'd like to spend it with us. We'd love to have you. Thursday, February 15th, or Thursday, February 22nd are open on the calendar. That would be at 10 a.m. if you still would like it at that time. That's still convenient for you.
Just for this is Steve Mills, just for the sake of keeping us all out of trouble, I would propose that we go for the Thursday, the 22nd of February.
I second that.
Okay, so we've got it for Thursday, February 22nd, 10 a.m.
Yes, sir. We're lightning buyers here. And if there's nothing else, thank you all for your time and your efforts in getting us all back together again. It's great to see everyone again. Deborah, welcome to the Advisory Council. And with that, we'll adjourn the Property Tax Consultants Advisory Council meeting today at 11:38.